SJC-12782, Commonwealth v. Francisco Marrero.
Mr. Maddox.
Good morning, Your Honors. My name is John Maddox for the defendant Francisco Marrero. An adverb modifies a verb, and then it modifies the entire direct object of the verb. That's page 536 of Cassidy, and that's in regard to an express knowledge provision in 10M. Like 10M, 10A has an express knowledge provision. It is not an implied knowledge provision. When you apply the Cassidy grammar of adverbs rule to 10A, the express adverb is knowingly. The verb phrase is has in his possession, and the entire direct object is a firearm, loaded or unloaded, as defined in section 121 of chapter 140.
Don't we have precedent all the way back to Sampson, early 1980s?
Sampson refers to the predecessor version of 10A. It's an implied knowledge provision rule, and it would apply. And the legislature changed that in 1990. Sampson is pre-1990, as is Papa.
So is it a little different, though? I mean, when you're dealing with a loaded gun, the danger is that you have a loaded gun. When you have a firearm, the thought is that, well, we don't want people with firearms unless they're licensed. And if somebody wants to rob a bank with a firearm, the fact that they don't know that the pin isn't working really doesn't seem to matter for the concern that led to the legislation, does it?
Well, it would be ungrammatical to read it in that manner, to say that it is meant, that firearm is meant in common parlance. I think the same could be said for 10M. That might be an argument to overrule Cassidy, that you don't want people to have large capacity weapons.
I really do appreciate how you started your argument, just right getting into the issue. But my question is, why grammar is one thing, but don't we have to also look at the intent behind the legislation and common sense?
Well, we
can't just limit ourselves to grammar rules, and obviously, if you look at the case law, we haven't.
This is a plain reading of the language. It seems to me that the legislature has to say what they mean and mean what they say. So I'm suggesting that this is what the statute says. If indeed it turns out that the legislature did not mean what they in fact said, they can fix it. That's their job, and they can change it and say what they do mean if this is not what they mean. But in the meantime, the court's job is to look at what they said and what they apparently meant through the language.
If we were to look at it the way you'd have us interpret it, can you go through with us how that helps your client in this case? Would
you like me to distinguish O'Connell?
Well,
what you're saying?
Well, what I'm saying is, even if we said that the statute should be read the way you're saying it should be, that he had to knowingly possess a firearm as defined in the statute, right? In this particular case, is there not enough evidence, circumstantial or otherwise, to show that he did know that he was?
I'm suggesting the facts of this case, there would not be sufficient evidence of knowledge of operability. There would be as to barrel length. He's holding the gun up. He can observe the firearm.
But didn't he shoot it twice?
Exactly.
Right.
Sorry?
He shot it more than once.
He shot it twice, yes.
Yes.
Over a period of two seconds.
Right.
There's no prior history. We're looking at the contemporaneous conduct, which would be pulling the trigger twice, 2 muzzle flashes, 2 shells found on the street.
Kind of capable of discharge, right, when it does discharge?
I'm sorry?
It's kind of capable of discharge when it in fact did discharge?
Well, it discharged, but we don't know whether they're backing out the definition of a firearm by saying that it emitted a bullet and therefore it must have been a firearm, that the shell was consistent with ammunition, therefore this is a firearm. But we don't know that Mr. Marrero knew that when he pulled the trigger.
Is this in the light most favorable to the government, this inquiry?
I believe so. I think.
So then there's a question of you see hoof prints and they're not, giraffes, they're horses, right?
No, Your Honor.
Like you talk about the starter pistol thing?
No, Your Honor. For example, with the muzzle flash, when a muzzle flash occurs when a firearm is discharged, that may be a bullet or it may be a blank. There's nothing in the record to that effect, but that happens to be reality. They're difficult to distinguish. So, but there's nothing in the record that would show that Mr. Marrero knew to be able to distinguish that, if there is a distinction, which there is not.
But this isn't a track meet, nor is it the case you rely on where he knew it was a blank gun. So I'm just not sure how you get over the hump when we look at this in the light most favorable to the Commonwealth.
I'm suggesting that there is insufficient evidence of knowledge of operability. He wouldn't be able to distinguish that a bullet had been emitted from the gun merely because of a muzzle flash. Similarly, he would not know what the sergeant testified to about the shell being consistent with the ammunition. There's nothing in the record to suggest that Mr. Marrero would know that. Indeed, I don't think a jury would know that in terms of the actus reus, let alone the mens rea. So I'm suggesting there's insufficient evidence of the actus reus because a jury doesn't know how guns work.
So someone gets pulled over, constitutional stop, there's a firearm found under the seat, nearly impossible to prove the case.
Not at all. That's the absurd example that the Commonwealth cites on page 28 of its brief. That happens to be very similar to the Tyreek Brown case. There may not have been 10N knowledge in Tyreek Brown, but there was 10A knowledge, and this is how it works. Mr. Brown was pulled over for a violation. There's no prior history, so we don't have that to work with as in Cassidy. We're looking at contemporaneous conduct. The contemporaneous conduct in a motor vehicle stop with nothing occurring prior to it and a gun in the car. There in Brown, it was in the rear console, so he would know that the barrel length was there's an implication that the barrel length is less than 16 inches because he put it inside a rear console. It has to be small enough to fit. But similarly, it's within his reach. He put it within his reach so that he could use it. That implies that he knew that it was operable. A lot of people want a firearm.
You could want a firearm to intimidate, but I'm saying under the seat. You're not confined by the console.
But don't you also have to prove capable of discharge?
Yes, Your Honor, as part of the actus reus.
So continue with Justice Lowy's example and show how the government's going to prove capable of discharge in the Tyreek Brown situation.
Well, you can take the gun, you can fire the gun. A ballistician can fire the gun.
Oh, I know that afterwards.
Test fire the gun in terms of the actus reus.
Under your theory,
Right.
In terms of knowledge, in terms of the defendant's knowledge, it depends on where in the car it is.
No, just take his example. So there's a gun
yes,
under the seat.
It's under the seat. If
Barrel
it's,
length is a no-brainer, right? How does the government prove it's capable of discharge? He knows it's capable
well, it depends
of
on which
discharge.
seat. If it's under his seat, it's within his reach. That implies that he has it ready for his use. That's what I would suggest.
So then every gun is capable of discharge, so the knowledge element of capable of discharge is a nullity.
No, Your Honor, it would be if somebody has it within his reach. So another example would be if somebody had a gun on his person during a drug sale. The implication would be that he has it for protection. That would imply that he has knowledge of operability. And there are a number of instances.
Why does that follow? I mean, he could be carrying a blank gun to intimidate. So that, I mean, that doesn't get you over anywhere.
Well, that depends on, not every case is an unrecovered gun case. In an unrecovered gun case, that would be more difficult to prove. But if you can look at the gun and see that it's a working gun in terms of actus reus, that wouldn't be a problem in your example.
Seems like in the way you're requiring us to do this, we're going to have guns fired and bullets recovered in every case to prove this.
I don't believe so. There's a number of
otherwise?
There's a number of factors in contemporaneous conduct that you can look at regardless of prior history. There would be the gun itself, bullets, bullet holes, threats, statements. If a person was shot, you would know that there was a bullet in the gun. Also, just more general things like furtive movements could connect it in combination with other factors, or consciousness of flight. So there are many factors. I'm suggesting this is an unusual case with scant evidence.
But you're saying that firing it twice, discharging it twice, and what, there were shell casings found? And shell casing found, discharging it twice is not enough.
That's correct.
And certainly, there's nothing in your argument that says that being under the seat would be enough if discharging it twice is not enough.
Well, if he's discharging it twice, he doesn't know whether the bullet is there or not.
No, I already understand that argument. I'm saying if discharging it twice with a shell casing right there is not enough to survive a required finding, okay, I want to take your argument. How is it being underneath the seat enough?
Here's the distinction. In this case, he was a passenger who was picked up. He had no prior contact with that gun. He has no idea what that gun is. In the case where somebody is in a car and has a gun within his reach, the suggestion is he put that gun within his reach so that he may use it.
What if your client had the gun under his passenger seat?
If you were the only person in the car, I would say it was still there. It would still have the implication of knowledge of operability and, I guess, barrel length. If there was another passenger, it would be more complicated. It depends. There are a number of factors in contemporaneous conduct. This is an unusually, it's a fairly odd fact pattern in the sense that there is no gun. It's an unrecovered gun case. There's no bullet. There's no bullet hole. There's no threatening conduct. This is, tomfoolery at the end of the night, no prior history. So it's a fairly scant fact pattern. And I'm suggesting here there's nothing in the record that suggests that he would know that muzzle flashes means a bullet, or that he would know that any shells were consistent with ammunition. If you look at the video, I don't think he's even looking down at the sidewalk. I don't even think he'd be aware on these particular facts. But it depends on the facts, and this is a scant fact pattern. I'm suggesting to you that in general, you would have either prior history or a number of factors that would be contemporaneous conduct, and that in most cases, it wouldn't make a dramatic difference whether somebody knew it was a gun in common parlance or a gun under 140, 121. I don't think this case makes that much of it doesn't create an absurd result, is what I'm trying to say. It's restrictive somewhat, I think, but no more so than the restriction in Cassidy for 10M.
So the jury instructions that would be required if you prevail would be that you, the jury, must find that he possessed a firearm and that he knew that the firearm could be discharged and that he knew that the length of the barrel was less than 16 inches.
Yes, Your Honor.
So the jury would have to make findings as to his knowledge as to its capacity to be discharged and as to its length.
Yes, Your Honor.
And I guess the alternative is we basically have interpreted Section 10A effectively to say you must be in possession of what we commonly think to be a firearm, and that firearm must be proven to be capable of discharge and must have a length of less than 16 inches, but he did not know that.
Yes, Your Honor. I'd like to point out that on page 535...
I guess the question is, the law doesn't seem broken right now. It seems, the result we have right now, frankly, is a lot more sensible than the result which you're proposing. So why should we change something that's not broken to something that probably would be broken?
I think you've already rejected the argument that the Commonwealth is about to make on page 535 of Cassidy. There was a 10C implied knowledge rule argument made. That's what they're doing here. This is an implied knowledge rule based on prior pre-1990 cases. So that's a virtually identical argument. You've already rejected that argument in Cassidy. I think you'd have to overrule that part of Cassidy to rule against Mr. Marrero. May I just touch on 12E very briefly, Your Honor?
Very briefly.
I'm making the same argument you heard in Kelly on October 2nd. I'd like to point out you can trip over your dog and set your gun off. That means you can violate the statute even if you're as pure as the driven snow. Ordinarily, for a strict liability statute, you have to be able to avoid the violation easily. That would not be so under that particular fact pattern. I'm also moving slightly beyond Kelly to say that I'm asking you to Cassidyize 12E so that you would have to know that the firearm you're discharging meets 14121. And I'm suggesting that the word knowingly, regardless of whether it's implied or express, has to be given its grammatical value. So I'm saying for the 12E at least, either way, implied or express, it has to be read grammatically and given its grammatical weight. If you do that, I would like to point out that it would affect 10C and 10H. But those are not before us.
One last question. I gather the defendant was found guilty of possession of a loaded firearm?
Yes, Your Honor.
I can't find volume 4 in what's given to us, but.
Oh, I'm sorry. I'll send it.
Is there any, was the jury instructed that they must know that it was loaded?
Yes, Your Honor, they were.
The jury was given the proper instructions?
Yes, they were, yeah.
Okay.
Yes, Your Honor.
Thank you. Mr. Charles.
Good morning, Mr. Chief Justice, Justices. Assistant District Attorney Jamie Michael Charles from Middlesex on behalf of the Commonwealth. As this court recognized in Cassidy, your primary duty in interpreting a statute is to affect the legislature's intent. And what my brother is asking you to do is to essentially ignore the legislative intent underlying one of the preeminent public safety statutes that we have in the Commonwealth, to ignore 40 years of precedent in interpreting what it means to knowingly possess a firearm for purposes of 10A, and to ignore roughly 30 years of this court and the trial court's application of that principle in 10A cases. And I would submit that that is unreasonable, particularly where he's asking you to do so on the basis of your interpretation of a separate statutory subsection that was not even enacted into law until 8 years after this court made the relevant amendment to 10A in 1990. And I think this court, it's not really similar to O'Connell like my brother tries to make it seem. You have to look at the history of 10A, which is a long history. I mean, I believe as this court acknowledged in Jackson, or it might have been Sampson, that statute dates back to 1906, and it's undergone a variety of amendments and changes over the years, I think roughly 30. And, you know, the most relevant one being that in 1975, this court created a minimum mandatory for that statute, and shortly thereafter in Jackson, this court said, well, in light of the severe penalty that attends a violation of this statute, you must, to satisfy due process, show that there was a knowing possession of the firearm. And then this court went on in Bacon, in Sampson, to interpret what that meant. And this court determined that what that meant is that when we're dealing with conventional firearms, and a conventional firearm sort of means what it says, essentially a pistol, a revolver, something that we, as people living in this country, which for better or worse has a prevalence of the possession and use of firearms, understand to be a gun. You know, not a flare gun, not a starter pistol, but a Smith & Wesson revolver or a Glock or something of that nature. If you possess that, then you essentially, and the jury can determine that you knew it was a weapon. And then if we also prove that you knowingly possessed it, and then it meets the characteristics of the relevant statute, i.e. it is capable of discharging a bullet, or with minor modification is capable of doing so, then you're guilty of the crime. And I think this court acknowledged in Brown last year that the 1990 amendment to 10A, which from an elemental perspective really only added the word knowingly, that's the only thing it changed. You acknowledged in Brown that that amendment was in response to this court's decision in Jackson. So I don't think you can just look at this as a blank slate like 10M, which was enacted with the word knowingly in there and which hasn't been amended at all. This statute has been consistently amended. And I think that the 1990 amendment, it's very clear if you look at the case law and you look at the legislative intent that that was done basically because this court had said you have to prove knowledge, not because the legislature wanted to impose this more stringent requirement, which I do believe would drastically change how this court and how the Commonwealth this court reviews and the Commonwealth prosecutes
So
this
what do we
crime.
do with what we said in Cassidy about, it has to be knowingly possessing the
So I guess
object?
two separate points on that. One, I sort of dispute that the as defined in Chapter 40, Section 121 necessarily has to be modified by knowingly. The reason that language is in there in 10A is because that is the first provision of Section 10 that uses the word firearm. And so the court is saying, by the way, any other time you want to understand what a firearm is, go to this section, you'll know what it is. If you note, every other time in 10A that the word firearm is mentioned, it's not as defined in General Law Chapter 140, Section 121. So frankly, that's just there so that the reader has something to refer to, because we also have to prove that the gun does meet the technical specifications of what we consider to be a firearm. But even if you don't want to accept that argument, I still think that, as Cassidy quotes other cases, ordinarily we rely on the language, but not to the exclusion of all other principles, not when it would be unreasonable, not when it would yield an absurd result. And I think if you look at the legislative history of this statute, this would unquestionably affect an unreasonable result. When this minimum mandatory was enacted for purposes of 10A, the court recognized, I think again in Jackson, that the Commonwealth was the first state in the United States to impose a minimum mandatory sentence for a firearm offense, a first-time firearm offense, possession. We also have the strictest, if not one of the most strictest regimes in terms of regulation of who can actually possess a firearm in the country. We allow police departments to make suitability assessments of people above and beyond whether they're actually barred due to some other statutory provision. It would be ironic for this court to interpret 10A, which is really the preeminent statute that helps to effectuate all of these firearms regulations and other provisions, in a way that makes it harder to prove that crime than almost anywhere else in the country.
Could you address the way the chief formulated the distinction between the Sampson test and the Cassidy test?
I think the chief hit the nail on the head.
And could you apply it to the facts in this case?
Sure. I do believe that under either view, other of the standard, the Commonwealth's evidence sufficed in this case. And I'll just take the more stringent standard for purposes of assessing it, because I think obviously...
Actually, go the other way. Start with the Sampson test just for a second.
Sure. So I think what we have here, if we're just talking about was this a firearm in the conventional sense, and did it meet the technical specifications? This court has recognized that, and I think it's in the Tuitt case, 393 Mass 801, that the burden of proving that a weapon is a firearm is not a heavy one, right? We've had cases, I think I can refer you to Fancy, for example, where the jury's examination of a gun, just a visual examination of it, was sufficient. I know we didn't have a gun in this case.
Yeah, from what I understand, and I may be misremembering the facts, but I thought he grabs the other guy's gun.
Correct.
So how does applying the Sampson test to guy grabs somebody else's gun and then he fires it in the air? He's doing this for show. How does he know it's a? How do we meet both tests in that context? It's not like he's robbing a bank, and you want to bring some firepower here. He's doing something stupid. And I just want to understand how we meet both tests when he does something stupid.
So
and we don't recover the bullets, and we don't recover the gun.
Viewing the evidence in the light most favorable to the Commonwealth and drawing reasonable inferences, we had several witnesses who were there who described what he did as firing a gun. The owner of the gun testified that was my gun. The gun was fired twice.
Did he say anything more than that was my gun? Did he give any more?
At the grand jury, but not at the trial.
Okay.
The gun was fired twice. There were muzzle flashes that were captured on the surveillance video. And by the way, I'm happy to transmit that video to the court. I don't believe you have it presently. I think it'll be helpful for the sufficiency analysis. And there were shell casings that were found in the exact spot where the gun was discharged repeatedly, multiple shell casings, within minutes when police responded. Numerous police officers, including a sergeant with decades of experience investigating over 100 firearms cases, firearms-specific training, testified that these were pieces of ammunition that were shell casings that were consistent with what is left over after a piece of live ammunition is discharged from a weapon. So we had all of those things. Again, we had, I believe, Miss
I'm just
Doobie.
bringing back bad memories of high school track. When they fire the blanks, do those produce any cartridges or anything? I just have no idea.
So I honestly couldn't tell you. I'd hesitate to give you a definitive answer not knowing, but I don't think that for purposes of a sufficiency analysis that matters. My brother sort of mangles this evidence in equipoise principle. We're talking about the evidence in the light most favorable to the Commonwealth. No one testified that these might have been blanks. No one testified that this was a starter pistol.
But he
If we
doesn't
view
have
the
to,
evidence
he
in
doesn't
the
have
light-
to do, he doesn't have to do any of that, right?
Oh, absolutely not.
It's just that weird formulation of consistent with. I understand that may be a product of not wanting to opine on, you know,
I really think this is somewhat like the Housewright case, 470 Mass, I think it's at 680. The court found that the jury had sufficient evidence that the defendant, quote, fired a weapon that looked like a gun, sounded like a gun, and flashed like a gun. And I cited a couple of other 128 decisions from the appeals court. I understand those are just persuasive. But I think that this is the sort of circumstantial evidence in a case where we didn't actually recover the gun, that you can determine that, A, he understood that what he was firing was a gun, particularly here where there was a shot, a pronounced delay, and then another shot that is memorialized on the surveillance video. And then also, where we have recovered shell casings, we have people saying that those are consistent with live ammunition, and we have numerous eyewitnesses saying that this individual fired something they believe to be a gun. So I think that's sufficient circumstantial evidence that this is a weapon that is capable of discharging a bullet, that it was, in fact, a loaded weapon, and that he discharged it in a firmly settled area, that, i.e. within 500 feet of a building. By the way, as to the discharging, Your Honors heard from me at length a couple months ago about why the Commonwealth believes that's a strict liability offense, so I won't dive back into it unless you have additional questions. I think basically the evidence I just summarized for you is sufficient under the more stringent standard, because I think that second shot here is crucial. If we're going to accept Housewright as the law, if somebody fires a gun, if it makes a sound that we understand guns make, if it muzzle flashes like we understand guns do, and then you fire it a second time, I think at that point you have the requisite knowledge that it is capable of doing the thing that it is required to be capable of doing. So I would argue that it's still sufficient under even a more stringent standard, even though I don't think this court should adopt that standard. I don't really have anything else to say about the grand jury issue. I think the statute, the standard of proof is obviously lower, and frankly, the evidence that came in at the grand jury was arguably more. Like I said, I think Mr. Perez, who was the gun's owner, who was immunized at trial, was a little more forthcoming at the grand jury. There was a fifth eyewitness who testified at the grand jury to hearing shots. There was testimony about a prior altercation at the Bartlett School where guns were fired, and people who were eyewitnesses who saw the defendant later fire a gun testified that they recognized those as gunshots. So I think it was even stronger at the grand jury, frankly. And the defendant's argument at the grand jury below, honestly, was not even that there was insufficient evidence as to his knowledge or operability. It was the absence of a ballistics certificate, which this court has said is not an impediment to a 10A conviction. And lastly, unless this court has any questions, I'll just rest on my brief as to the pretrial identifications. These were known individuals. They knew who this individual was. I
assume he wasn't wearing a red shirt at the time of the...
No, in fact, he was shirtless at the time based on the evidence, and two of the individuals depicted in the photo array were, in fact, shirtless. So if anything, he did not resemble what he looked like at the time he fired the shot, because the testimony was he had given his sweatshirt to Miss Doobie and therefore was and is depicted on the surveillance photo as being shirtless. So it's not the same thing he was wearing. And there was another person in the photo array, a singular person who was wearing a black T-shirt. So I don't think the fact that he happened to be wearing a T-shirt made any difference where the judge made a finding that all the physical characteristics were the same. I think this is basically on all fours with the Arzola case that you decided in 2015 that I cited in my brief. So I think there's no reason to disturb the judge's opinion. So I guess if there are no further questions, I would ask that this court affirm the defendant's convictions and affirm that the current interpretation of General Law 269, Section 10A, is the proper one. The defendant need only know that what he possesses is a firearm in the conventional sense. Thank you.
Thank you.